people who've taken time out of your busy days to join this session. And of course, there are so many more sessions happening during the course of this week. It's good to see some new names and also some familiar names on the participants list. I did pop my email on the chat. It stops at, it's rebecca@attree.co. It stops there, there's no error, there's no UK or no com afterwards. Please feel free to reach out and connect with me after the event if you'd like to. And I've also popped a link to my e-guide on international dispute resolution that you can download for free at the click of a button. But so many people are now involved in international mediation, and I'd just like to say that actually, you know, many of us, even just working domestically, our mediations are going to touch areas of cross-culture and different languages, just by virtue of the fact that the UK is now such a multicultural community and so diverse. And so I think probably, if I were to ask how many of you are involved in international mediation, if you were each to actually think for a moment, you would probably say yes, in one shape or form. And for me, I think international mediation raises further questions, further complexities, and I'd like to talk about those. But before I do, can I just share with you this little advertisement which I've put together on a form of graphics. Question: why would this advertisement for medicine not work globally? Anyone who wants to put their fingers on the chat button and type in, please feel free. Think laterally. So we have a picture of somebody ill in bed. Then they take some medicine and then they feel better. Stephen Hall, yep, you get the prize. If I had some chocolate biscuits, I would be passing them to you right now in the room. Absolutely, it doesn't work in Arabic. The reason being that in Arabic and also Korean and some other languages, you read from right to left. So yeah, on its face, a great idea to use graphics, but actually in a language that reads from right to left, it gives the opposite message to the one intended. The person is feeling great, and then they're taking their medicine, and then they are unfortunately feeling unwell in bed. Lovely to see some of you putting your videos on. Fantastic. You can see that I do encourage interaction, and real live smiley faces as well as emojis are all the better on a Monday morning or a Monday evening, should you be joining from Australia, as the person on my pre-meeting call was doing actually this morning. So what are the challenges? What are the things that we've got to overcome? So I would say that mediating disputes between parties from different countries, cultures, languages, religions, and business practices creates extra challenges. And as I've said, it's on our doorstep. So how can mediators, advisors, and parties best prepared to meet these challenges? I would imagine some of you are mediators, possibly some of you are advisors, so perhaps some of you are both, and perhaps some of you are parties to dispute. Actually, I've experienced what I call the 360 degrees of mediation. I actually came to mediation because I was a party at a mediation company I'm a director of, had a dispute, and I went to the mediation a little unsure what it was going to be like, because until then I'd just been a solicitor and a company director, and went to the mediation, and that for me was a light bulb moment where goodness, you can settle something in a day. And it was that inspired me to become a mediator. I've also from time to time been a mediation advocate, so I'll attend mediations with people in their room as their advisor, not as a legal advisor, but as a mediation advocate, someone assisting them with their case. So but most of the time I am the mediator, but I think seeing what it is like from all sides is definitely something that for me has been really useful. Thank you, Nikki. The thumbs up is rude in some cultures. Absolutely. A really good comment, and thank you. It's something I think to be aware of, that when we are using Zoom, we only have our hands to use, and so we need to be very careful what it is we are doing with our hands. Okay, so what are my key topics here this morning? And here I am, by the way, mediating in the rooms that I sometimes use, just overlooking London Bridge there with Tower Bridge behind me, those of you joining from overseas. So awareness and expectations. Secondly, language, culture, religion, business practices. And then what about the mediation process itself? What are people thinking and expecting when it comes to that? So just a small set of agenda here in our Monday morning. I can't cover it all, but let's see what we can look at. Okay, so firstly, I think it's to have awareness, the cultural iceberg. And you can see here a whole raft of things that are different in different countries according to different people. And you'll see that the tip of the iceberg are the things that we actually can see perhaps quite visibly, and they can be reasonably obvious. So styles of dress, facial expressions, although sometimes facial expressions can differ from one culture or country to another. But under the iceberg, what is going on there? A whole raft of things. Concept of fairness, so important. What is seen to be fair? Quite often in a mediation, I may find that people are close to reaching a deal, but one person, although all the risk assessment points that they should accept what's on the table, they may say, doesn't feel fair, this doesn't feel right, why really should I give in and take this? And sometimes the answer is because actually asserting your legal rights is going to cost you money, and your risk analysis is actually you are better taking what's offered to you, but is that fair? And even I've had situations where, particularly in probate and Inheritance Act cases, perhaps there are 3 siblings in one room, 1 sibling in the other, and actually the 3 siblings between them decide, do you know what, we're going to share this in a different way, we're not going to share this 3 ways. Should the other person know? No, they don't need to know that. The agreement needs to be drafted carefully such that it is a payment over to the 3. But concepts of fairness, I think, very often go to whether or not people will agree to a settlement or not. By the way, a copy of these slides will be available afterwards if you are thinking that you'd like to look into more of these topics in more detail. So how do we build awareness? Well, by research. There's an amazing book that I've read over the years many times called How to Negotiate Anything with Anyone, Anywhere in the World. Just a small brief there by somebody called Frank A. Cuff. He's an American author, so you do need to read it with a little bit of a pinch of the fact that it is written from an American perspective rather than a UK perspective if you're coming from the UK. But it is fantastic because it tells you things like, what is it okay to talk about in a first meeting with someone in the lift? How quickly will people get down to business? And there are different pages for different countries, and it has been updated about every 3 or 4 years. So I actually have about 4 editions on my bookshelf. And one of the things I've been interested is to see how that book has slightly changed over the years and what how culture has changed. So it's a constantly moving landscape, but I think awareness, so finding out who are you going to be mediating, what is their background, looking them up on LinkedIn, doing the company search, never assuming, because just because of course someone has a surname that might indicate they come from a certain country, it may not be the case, because it could be from parental background that actually they've been born and brought up in England and they are entirely British. So never make an assumption, but awareness I think is the first thing. So let's now move into how do countries fall on the context continuum. I'm just going to check that we didn't, there we go. So we have these approaches which those looking at cross-culture look on the one hand at high context, and you'll see on this continuum, so it is a moving scale. The Japanese, the Chinese, Arab cultures, Greek, Mexican are all high context. Contrast with low context, where we've got, for example, German, Swiss, German, Scandinavian, American, English Canadian, and then you'll see English is more or less in the middle, but perhaps slightly on the low context end. And I'm going to explain really how does the position of a country on this continuum affect how people deal with conflict. Apologies, there are some notable large trading areas that are not included on this. Africa, for example, most African countries are high context, but South Africa, white South Africans tend to be low context. India, high context. It would be probably somewhere between Arab and Greek on the context. But if any of you have particular country speciality and you'd like to pop on the chat where your country that you work a lot with is, or particularly when I've spoken more about it, where you think they may be according to what I'm saying, I'd be delighted, or indeed even to tell me after this webinar. So how does this work in terms of awareness? Well, and how does it work in terms of dealing with mediation? How does culture impact on behavior, communication and conflict? And I've just picked some key areas in terms of how does it differ. I mean, the main way I think to think about high context countries is such as China, for example, is that people are less direct. People will talk around the topic. People may even say something but not finish their sentences. Italy is reasonably high context, and I remember an interview with a well-known lawyer, Avvocato Dell'Olio, and she kept speaking, but then she would stop and she would sort of do this as if the person would need to finish the sentence for them. So it's a very indirect way of communicating. Contrast with the low context, I think many of us would think Germans, Swiss German, Dutch people tend to be a lot more direct. So they will say it as it is. They will, as we say in England, call a spade, and they will be much more direct. So how does that work when it comes to being a mediator? Well, many of us will know that as a mediator, a really important part of our toolkit is to ask questions. The corollary of a indirect verbal approach is that you shouldn't ask too many direct questions. You need to be quite indirect. You need to be even more open in your open questions. So giving people gentle pointers from which they will talk. Whereas in a direct verbal low context culture, you can ask people and expect a reasonably direct answer. They won't be offended. What does that mean to the mediation process? It's probably going to take longer with a high context culture because you're going to have to skirt around the topic rather more. Whereas in a low context, you could be more direct. So a simple thing, well, simple to the mediator, but not simple to the parties. You know, can you afford to pay? You know, how are you financially? An awkward topic to address with someone you've never met before, and there you are as the mediator. In the low context, you could be more direct and say, how are your resources? What is your ability to pay the sum that at the moment you are suggesting or it's being requested of you? Whereas in the high context, you may have to say something like, how comfortable are you with this settlement proposal? And then to hone more into what actually the financial aspects are. So the other points that are here on this slide and the comparisons, in the high context, relationships are important. And so often you will really need to work on the relationship as a mediator before you get into the substantive issue. We're all, I'm sure, aware of the importance of an apology if it can be procured. I think in a high context culture, looking at, is there something that people need to apologize for? Even they're sorry that they're having to actually be here and be addressing these issues in this way, and things weren't sorted out sooner. But working on the relationship can be very important. And sometimes people in a high context culture aren't ready to go forward to look at the substance until that relationship issue has been addressed. On the other hand, in the low context, you'll find people coming in and being much more pragmatic and commercial. And it's only later that if you were to look at it with them, you might say, how do you feel about this? They are unlikely to tell you how they feel. They will tell you more how they think, and strategically, what are they wanting to do? So because in a high context culture, the verbal, what people say is less direct, this means that the non-verbal is even more important. And so people coming from Arabic countries, from China, they are going to be really noticing the non-verbal cues so much more acutely. How does that impact on online mediations? I think in the first instance, people coming from high context cultures are going to be more resistant to the idea of an online mediation, because they're going to feel that they're not going to get the whole message, because for them so much of the message is in the non-verbal. But in actually my experience, those who have been reluctant, when actually they have decided to do an online mediation, they've actually been really fine with it, and they've actually found it to be effective. I think a couple of tips on that. One is maximum 2 people per device. You know, that system where maybe you have a hybrid approach and you have a whole team of people in one room joining from a big screen in, let's say, a boardroom, doesn't really work that well from the point of view of the mediator, because you can't see people's faces so well. Yes, it works well for those people in the room together because they can have really good direct communication together. But I would always say, even if you're all joining physically in one room, please maximum 2 people per device, so that I can actually see you. And you can get around the issue of the feedback, because you've got quite a number of people all with their microphones on. Get them to mute and have a 360 directional microphone that's just attached to one device. When it comes to the low context, because of the low use of nonverbal, typically those people coming from those countries will be much more comfortable with the online experience. So a few other things: time and space, very important as a mediator. Space is shared in the high context, so you may find that people are more willing to have a joint open session because of that, whereas the low context, the joint is less desirable. We'll talk about that a little bit more when we come to process. And in the high context, people won't mind so much if the mediator is spending more time in one room or another, and the timing is much more flexible. I'm sure we're all aware that the need to actually have a set time for the mediation. In my early days, occasionally people would say to me, Rebecca, can I book you for 4 hours? And if need be, can it just go on after? And whereas on the one hand, I wanted to be flexible and help people along the way and be cost effective, I quickly realized that that doesn't really work for the advisors, because they charge their hourly rate and they can't just book themselves out for the day, but perhaps only work for 4 hours. And the other thing is that actually, everything has its natural timescale. And if people know that the mediation is booked for 4 hours, they will negotiate according to that 4-hour time span and that sort of timetable. Whereas if there's 8 hours, they will work towards that 8 hours. Certainly in the low context, people will want to look for strict timekeeping, and they may be more for having short time limited mediations, possibly 4 hours if it's a relatively straightforward matter. The last point about how do people learn, I think does go to how people behave at a mediation. In the high context cultures, people have many different multifaceted learning. They will learn from many different methods, from videos, from presentations, and typically it tends to be more instructor-led. This can mean that those people who then, when in the situation of a meeting with one person in authority, the mediator, they will expect the mediator really to take quite a strong lead. Whereas in the low context, where learning is rather more inductive and people are much more given a set of scenarios, and they have to deduce from those scenarios certain outcomes when it comes to their learning. They will be used to figuring it out more for themselves. Of course, as facilitative mediators, which is the general approach in England, although some element of evaluation I think is usually there in any mediator's toolkit, I think perhaps the high context is going to be looking even more for the facilitative mediator, whereas the low context is going to perhaps be looking more for the evaluative mediator. But personally, I don't really like to differentiate with those terms very often. I'm using it here to just give an explanation of really how much would the mediator lead and encourage, or on the other hand, be facilitating. So how do you deal with all of this as a mediator in terms of if you have perhaps someone coming from a high context country in one room and a low context country in the other? Well, you can have a bit of a conundrum going on, because the people in the low context room will be saying, go tell them how it is, Rebecca. Please go and tell them in no uncertain terms how we see it, how we feel about it. And actually that may not be appropriate in the high context room, because it might be too much information. It may be offensive to them. They may take issue with such directness. They may be really quite uncomfortable. And of course, as a mediator, your role is to build trust and rapport with each party. And I usually say, you know, I'm a bit of a chameleon. I'm one person in one room and one person in another. And in this situation, I certainly would be. And it can be challenging, because as the mediator, you would need to discuss with the low context room how you might disclose to the other room certain things, but in a way that the high context room will receive it and that they will take it on board. So it may actually be necessary to say to the low context room, listen, such a direct approach may not actually work in there. I think you might need to give me more scope and more authority to talk around the point with them. Is that okay? And it may take me a little while, because I may not be able to go immediately straight to the point. Equally, from the high context room, they may be quite limited in their disclosure authorization. They may not want you just to go in and call a spade into the low context room, because they're not comfortable with that. So the communication does need to reflect on whose behalf you are speaking. So those are things to think about and to be aware of. And in terms of also how you spend your time, and that mediator's acknowledgement in the opening speech, you know, don't read anything into my movements. I may take longer in one room or another, I think is particularly important when it comes to a cross-cultural mediation. So other things in terms of how does culture impact on the approach to conflict. So a few more points to think about. Really, what about the actual conflict itself, and how do people deal with conflict? Of course, it is individual, and I should give all of these slides the health warning that we are all individuals and we mustn't pigeonhole people according to certain scales. However, hopefully some of this is interesting in terms of a backdrop, in terms of general approaches. So those coming from a high context culture, those, for example, in China, are going to see the conflict as very personal. It's personalized. That approach of, you know, separating the people from the problem is not something that they do very readily. They will take it to heart. Contrast with the low context, where conflict is depersonalized and it's very much more just looking at the facts. This is another reason why the apology can be really important in the high context, but it can actually be a barrier to getting to a settlement, in that in the high context cultures, sometimes it's not possible to begin to address the substantive issue until the personal issues have been resolved. Whereas in the low context, that would be a plus, that would be an adjunct to the issue. The main thing is dealing with the substantive dispute itself. And in the high context, people can actually feel more personally threatened. And so there is a need, particularly if you do have a joint open meeting, to, as mediator, really manage the meeting chair it very strongly, and not to allow interruptions, and to make sure that everybody knows that when one person is speaking in their first presentation, that there should be no interruption. And occasionally I might even say to one person, look, you know, an interruption can even be non-verbal. You know, if you're rolling your eyes or tapping your fingers or something, that in itself is an interruption. So please give respect to the person who is speaking. Contrast with the low context culture, where there really is much more of a focus on the rational solutions, and they are more naturally going to separate the people from the problem, and to think this is a problem that's arisen as a result of the interaction between our two companies, and the individuals are sort of peripheral to that. This is a situation that's happened, and so you're going to be looking much more at a problem-solving approach. So in all of this, how does this take you in terms of mediation? I think in the low context arena, you're going to have a lot more focus on perhaps legal arguments, perhaps Excel spreadsheets. I, for example, had a case relating to an agency agreement with an agent appointed in Switzerland, and there were so many spreadsheets that they had brought. Now, as a mediator, I tend to try to step back from the detail and get people to look at the big picture. So we were always only trying to look at the bottom line of these Excel spreadsheets, but the level of detail was phenomenal there. Let's just think a little bit also about ethical considerations, because I think when it comes to cross-cultural situations, different countries and cultures' approach to what is okay ethically and what is on the borderline can change, and different people can have different views in terms of what is okay. I think from an English point of view, many of the things here on this slide would be not okay. And one of the things is, you know, overhearing conversations, but that can even go further to where one party is speaking in another language, and they assume that others can't understand. Maybe some of you have been in that situation. I had that situation where, as a lawyer, I speak Italian, and the party on the other side were Italians, and they were speaking in Italian. They didn't realize that I understood. So immediately I said, parlo italiano, capisco tutto. You know, I speak Italian, I understand everything. Now, really, I only had, you know, one moment in which to say that. If I didn't say that straight away, clearly I couldn't say that, you know, at the end of the meeting, because that just would have been completely inappropriate. So sometimes you do need to think on your feet, and you need to think quickly. But perhaps if you're aware as a mediator of any issue, it is to address it with people. And if others say, well, what's the problem with that? It may be necessary to explain that actually in our culture there could be. So these are things to be thinking about carefully. I do also remember I had a case with some Russians a few years ago, and they gave me a piece of paper and they said, Rebecca, go take this into the other room, go show them, this will really convince them of our case. And as is always the case, I read this document carefully, because I never want to be just a messenger, I want to actually look at what's going on inside it. And I turned over the page, and it said at the bottom of this email that the Russians had written, and if you don't do this, we will kill you. And I read this and I said, well, what's going on here? And they said, oh yeah, we just wrote that, you know, it's just a turn of phrase, you know. And I said, but if this went before an English judge in evidence, how do you think this would go down? And they said, well, yeah, we could answer to it. And this was, of course, within the mediation process. It hadn't yet got to disclosure, and if it didn't settle, that would be something to consider. But I said, do you really actually want to disclose this right now at the mediation? And they said, oh, I see, okay, not. So you know, sometimes these things can come about. In terms of other issues, I've seen aspects of the confidentiality of the mediation dealt with perhaps quite loosely. I had a mediation that was taking place at a venue that was at a venue that was the address had in it clown court, and somebody put on social media, "I'm going to a meeting today with a bunch of clowns," and posted a picture of clowns. And the party in the other room saw that on social media and showed it to their lawyer, and immediately said, no good faith, you know, these people are making a mockery of this mediation. And so I had to go back into the other room and say, look, it has come to the other party's notice that you have posted this. Can I just talk to you about, you know, the seriousness of this mediation, the need for you to come in good faith, and also that actually confidentiality about the fact of this mediation endures beyond just speaking to people, but also putting anything on social media. So could I please ask you not to put anything else on social media at all? So things can be quite blurred and quite ephemeral as well. Okay, so let's just think a little bit about the mediation process, coming on to my third point here on my key topics. I've talked about awareness. I hope that some of the things I've spoken already about you will consider before you go to a mediation. Language, culture, religion, by the way, I haven't particularly mentioned that, but I think something on religion is, are people, for example, looking for a Sharia compliant outcome? I've had a number of mediations where people know that if they went to the English court, it would be decided according to English law, and it would be pretty unlikely that a Sharia compliant outcome would be given. So are people actually coming with that that background and that hope? In fact, I even had one mediation where it was 10 siblings, and I took the instructions from a lawyer who was coming with their one client who was one of the siblings, and I understood, because the mediation was set up through them, that the other 9 would be in the other room. But when I got there, there was one person who immediately when I arrived sort of tapped me on the shoulder and said, "Rebecca, good to meet you, good to be working with you today." And I said, "Yeah, fantastic, great, lovely to meet you." And then they said, "I'm going to be working right alongside you." And I went, "Oh, okay, good. I like to work closely with people at a mediation." No, Rebecca," he said, "I'm the eldest brother, so until now, I have been involved in this case, and I've been mediating it between my 8 siblings and the other one. So, you know, I'm going to be following you and coming with you. I'm your co-mediator for the day." So I had to take them into another room and explain to them that actually the process didn't work like that, and they needed to decide if they were going to go into one room or another, or were they not going to be involved in the mediation. So that was really quite a surprise, I think, to them and to me. They decided to go into the room with the 8, but by lunchtime, the 8 had decided they didn't really like that person in their room, so he was quietly and politely asked to leave. And so he then had to go and sit in the corridor and be separate. So a tricky one, that, but you know, that was their expectation. In that situation, ideally, I would have spoken to each of those people. This was back in the day, it's probably about 8 years ago, before online was really very prevalent, and before actually typically you'd have a call with most of the parties before the mediation. That was more in the day where you would set it up with one solicitor, and then it was one of the siblings on the other side that I set it up. So a few words about process and expectations. How might the process differ? So what I would say is that it's amazing how different the different processes are. So for example, in Germany, it's expected that the parties will remain with the mediator at all times. And actually, if the mediator were to put people in separate rooms and go see them separately, like we would do in the UK, that could actually build mistrust in the process and mistrust in the mediator, because in Germany, the whole idea is that the mediator spends the time with both parties all of the time. And other countries, New Zealand, quite the opposite. Well, the same as Germany, expectation of a joint open meeting. The US, quite the opposite. People will be in their different rooms and there they are likely to remain for the whole of the mediation. In the UK, I'd say it's probably these days about 50-50, although in my experience with online mediations, people are less willing to have joint open sessions. They really want to use the time as efficiently as they can, and they see it that a joint open session may not be very efficient, even though I say, look, it's good to actually see people even online. So what's the expectation there? Another thing is, does the country they're coming from actually have an approach of mandatory mediation? Many of you may have seen the discussions that we're having in the UK about should mandatory mediation be introduced. It isn't, of course, at the moment, but in some countries, for example, in Italy, there is some aspects of mandatory mediation. Greece, Turkey, they do have aspects of mandatory mediation, and indeed, in Italy, there are tax advantages of entering into a mediated settlement agreement. So are people coming thinking, even if it's a mediation under English law according to an English dispute and potentially English proceedings, if they're coming from a country where mediation is mandatory, they're going to be coming from a different viewpoint. What's the language of the mediation going to be? Really important to agree straight up, because I've had situations where it's agreed that it's English language, but then even in a joint meeting, one party will be speaking to each other in another language that others can't understand, which of course is impolite and tantamount really to whispering. I had another mediation where somebody came who was Chinese, and it was only at the mediation it became apparent that they couldn't understand English very well. And they said, no worries, I have my son here, he's going to translate. Now the son was actually there as a supporter, but as the mediation progressed, it became apparent that the son did actually have a bit of a vested interest in the outcome, because in the other room was his sister, and effectively what each of them would ultimately inherit was really sort of a bit at stake. And so fortunately, the mother, who couldn't understand English so well, had also with her husband, and occasionally I would check in with the husband to make sure that the son was truly translating. But somebody else apocryphally told me recently that they had actually had a translator at a mediation, and one person would say a whole lot of things, and then the translator would literally say one sentence, and it's, well, have you really translated that? You know, if you said all of that in one sentence, you know, how is that actually working? So what is actually happening there is important, but sometimes bilingual adaptations can be made. I mean, I had a most unusual situation where I had Italians in both rooms, and and solicitors who didn't speak Italian. That's of course understandable because it was here in England, but each of the parties wanted to at least meet the solicitor from the other room, but they didn't want to have a joint open session. So what we agreed was that the solicitor from one room would come into the other room, speak in English, but I would translate it into Italian. So that way those Italian parties got a flavour of the solicitor on the other side. I know we shouldn't use that expression, but you know, that was what was going on. And they could get a feel for what they were saying and who they were, and they could put together the body language with it as well, without actually it being a full joint open session. Of course, I had to give a health warning that, you know, I'm a mediator, not a translator, but that I was wanting to convey that. And it also meant, of course, that the English solicitor could then understand what their opposing person, the other solicitor, was saying to their clients. So plenty to be thinking about in terms of that. A couple of other quick things to think about from the party's point of view is limitation running. You know, is the fact of there being a mediation in England, is that stopping limitation periods running overseas? Generally not, but if it's a cross-border mediation within the EU, remember that the EU mediation directive still applies within the EU, not of course with the UK because of Brexit to a large extent. There's one or two bits of it that do apply, but fundamentally, if you've got a purely UK mediation, then limitation and time to bring proceedings will continue. And then, by the way, just looking after yourselves as mediators and ourselves, have you got insurance to mediate internationally? I've looked into this over the years. Generally, most insurers, and my disclaimer here, I'm not here to give advice, but generally what I've found is that if I'm mediating in England, based in England, that will cover. But if you have parties coming from the US, you may need to have extra cover for that. And be careful if you're doing it online, you know, where people are joining from and exactly what are the terms of your insurance, because certainly many insurers do have a carve out for working in the US or with the US. And if all of this just seems quite a lot, then consider having a co-mediator. If you feel that you are absolutely fine, for example, on the commercial mediation aspect, but you'd like someone to have who has more cultural awareness of the parties, then think of that as well. So I think, to summarize, that the best preparation is to know what everyone is expecting and assuming. Have that pre-mediation chat, ideally with not only advisors but also parties, and find out what everyone's really expecting from the mediation process. Important not to stereotype, but to have awareness and to think laterally, just like that advert that I showed at the beginning. You know, even Facebook got it wrong by calling their new group, the rebranding was Meta, which means dead in Hebrew. The car Nova didn't get very far in Spain because Nova means it doesn't go in Spain. So a need to think laterally. And even my mediation recently nearly fell apart because one of the people's names had one letter missing. And when that was spotted by the eagle eyes of the solicitor, the explanation was, I believe in numerology. I'll leave that one with you. Always something new to learn at any mediation. So thank you for your interest. I'm delighted to see that there's some comments and perhaps questions on the chat. Really look forward